Legal arguments are supposed to be based on logic, precedent, and reasoned interpretation of the law. Sometimes lawyers win by arguing things so absurd that everyone assumes they must be joking until the verdict comes in. 1. A defense attorney in Texas successfully got his client acquitted of murder by arguing that the victim deserved to die because he needed killing. The defendant had shot a man who'd been terrorizing the local community for years with threats, violence, and general menace. Nobody in town liked the victim and many were afraid of him. The defense attorney stood before the jury and essentially argued that while his client had indeed killed the man, the killing was justified because the victim was such a terrible person that society was better off without him. He used the old Texas legal concept of "he needed killing," an unofficial but culturally understood idea that some people are so troublesome that killing them is almost a public service. The prosecutor objected strenuously, arguing that personal dislike doesn't justify murder. But the defense attorney painted such a vivid picture of the victim's reign of terror over the small community that the jury deliberated for less than an hour before acquitting. The judge was reportedly shocked, but couldn't overturn a jury verdict. The "he needed killing" defense isn't actually in Texas law books, but this lawyer successfully convinced a jury that sometimes murder is justified if the victim was sufficiently terrible. The defendant walked free despite admitting to the killing, proving that in some communities convincing a jury that someone needed killing is a legitimate legal strategy. 2. A lawyer defending a wealthy teenager charged with vehicular manslaughter while driving drunk successfully argued that his client suffered from affluenza, being too rich to understand consequences. The teen had killed 4 people while driving drunk, but the defense attorney argued that his wealthy upbringing meant he'd never learned that actions have consequences. The lawyer brought in a psychologist who testified that the boy's parents had never disciplined him, never taught him responsibility, and essentially raised him to believe he could do anything without facing repercussions. The defense argued that sending him to prison would be unfair because his privileged upbringing had prevented him from developing the moral compass that would have stopped him from drunk driving. The judge bought the argument and sentenced the teen to probation instead of prison. Public outrage was immediate. The idea that being too wealthy to understand right from wrong is a valid legal defense seemed to make a mockery of the justice system. But the affluenza defense worked, and the teen avoided prison time for killing 4 people because his lawyer successfully argued he was too rich to know better. 3. A criminal defense attorney got his client acquitted of robbery by arguing that the surveillance video showing his client committing the crime couldn't be trusted because all black people look alike, and therefore the person on video might not be his client. The argument was jaw-droppingly offensive, but the lawyer doubled down, bringing in witnesses who claimed they couldn't tell the defendant apart from other black men. The prosecutor played the video repeatedly, pointing out distinctive features, clothing, and tattoos that clearly matched the defendant. But the defense attorney kept hammering that eyewitness identification and video identification across racial lines are notoriously unreliable. He cited studies showing people struggle to distinguish faces of races different from their own. The jury, which was predominantly white, apparently found this convincing despite the overwhelming video evidence. They acquitted, unable to say beyond reasonable doubt that the person on video was definitely the defendant. The prosecutor was furious, pointing out that the defendant had distinctive tattoos visible in the video that perfectly matched. But the absurd argument that the jury couldn't trust their own eyes worked, and the defendant walked free. 4. A lawyer defending a man accused of stealing a car successfully argued that his client didn't steal the car. He just borrowed it indefinitely without permission, which isn't technically theft. The defendant had taken a car from a parking lot, driven it for 3 months, and was caught when police pulled him over for a traffic violation. The prosecutor charged him with auto theft, but the defense attorney argued that theft requires intent to permanently deprive the owner of property. Since his client always intended to eventually return the car, it wasn't theft. It was unauthorized borrowing. The judge asked if borrowing something for 3 months without permission wasn't essentially stealing. The lawyer argued, no, it's only stealing if you never intend to give it back. He couldn't prove his client intended to keep the car forever, therefore it wasn't theft. The prosecutor argued that taking someone's car without permission for 3 months is obviously theft regardless of eventual intent. But the lawyer had found a technical loophole in how the theft statute was worded. The judge ruled that without proof of intent to permanently deprive, the theft charge couldn't stand. The defendant was convicted of a lesser charge of unauthorized use of a vehicle, which carried minimal penalty. The absurd argument that borrowing something for months without asking isn't stealing somehow worked on a technicality. 5. A defense lawyer got a drunk driving charge dismissed by arguing that his client wasn't actually drunk while driving. He only became drunk after he stopped driving. The defendant had been pulled over and registered a blood alcohol level well above the legal limit. But the lawyer argued that his client had been sober while driving, pulled over for an unrelated reason, and then while sitting in his parked car waiting for police, he drank a bottle of vodka he had in the vehicle. Therefore, the breathalyzer test administered later measured alcohol consumed after driving ended, not during driving. The prosecutor called this absurd, pointing out the defendant showed obvious signs of impairment during driving. But the lawyer argued there was no proof his client had been drinking before stopping, only that he was drunk when tested. He claimed his client panicked when pulled over and drank the vodka in stress. The prosecutor couldn't prove the defendant had consumed alcohol before stopping the car versus after. The judge reluctantly dismissed the DUI charge because the burden of proof couldn't be met. The defense attorney had successfully argued that a man caught extremely drunk in a car immediately after driving had only become drunk in the moments after parking, and somehow the legal system couldn't prove otherwise. 6. A lawyer defending a shoplifter successfully argued that his client couldn't have intended to steal because she was sleepwalking at the time. The defendant had walked into a store, filled a bag with merchandise, and walked out without paying. Store security detained her in the parking lot with stolen goods, but the defense attorney brought in sleep disorder experts who testified that his client suffered from sleepwalking disorder and had no conscious awareness of her actions. The prosecutor pointed out that the defendant had driven to the store, selected specific items, concealed them in a bag, and attempted to leave. Complex actions requiring conscious thought. The lawyer countered that sleepwalking can involve complex behaviors and his client had no memory of the incident. The jury couldn't prove beyond reasonable doubt that she'd been awake and aware during the theft. The sleep defense worked despite how unlikely it seemed. The defendant was acquitted of theft charges because the lawyer successfully convinced the jury she'd shoplifted while unconscious, even though she'd performed a series of deliberate actions that suggested full awareness. 7. A defense attorney got his client acquitted of assault by arguing that his client thought he was in a video game and didn't realize he was hurting a real person. The defendant had violently beaten someone in a bar fight. The lawyer brought in psychiatrists who testified that his client was so immersed in violent video games that he'd suffered a psychotic break and believed he was fighting a video game character, not a real human. The prosecutor argued this was absurd. The defendant clearly knew the difference between video games and reality before and after the incident. But the defense presented evidence that his client had been gaming for 48 hours straight before the assault and expert testimony about gaming-induced psychosis. The jury apparently found this plausible enough to create reasonable doubt about intent. The defendant was acquitted of assault charges but committed to psychiatric treatment. The absurd, "I thought reality was a video game" defense worked because the lawyer convinced the jury that excessive gaming had temporarily destroyed his client's ability to distinguish fantasy from reality. 8. A lawyer defending a man accused of indecent exposure successfully argued that his client's nudity was protected artistic expression, not a crime. The defendant had walked down a busy street completely naked in the middle of the day. Police arrested him for public indecency. The lawyer argued that his client was performing a piece of performance art about body positivity and societal repression. He brought in art critics who testified that nudity in public spaces has been recognized as artistic expression. The prosecutor argued that walking naked down Main Street isn't art, it's exhibitionism. But the defense successfully framed it as First Amendment protected speech. The judge ruled that without proof the defendant's nudity was intended to sexually arouse himself or others, it could be considered artistic expression. The indecent exposure charge was dismissed. The defendant walked free because his lawyer successfully argued that being naked in public isn't a crime if you call it art, setting a precedent that caused headaches for law enforcement dealing with future nudist artists. 9. A criminal defense lawyer got drug possession charges dismissed by arguing that the drugs found in his client's pocket weren't actually his client's drugs. They belonged to the pants. The defendant had been arrested with cocaine in his pocket. He claimed he'd borrowed the pants from a friend and didn't know about the drugs. The prosecutor argued that possession is possession regardless of who owns the pants, but the lawyer found a technical loophole in how the possession statute was worded, arguing that his client had no knowledge of the drugs and therefore lacked the intent necessary for possession. The prosecutor pointed out the drugs were literally in the defendant's pocket while he was wearing the pants. The lawyer countered that his client had borrowed pants and couldn't be expected to search every pocket before wearing them. The judge ruled that without proof the defendant knew the drugs were in the pocket, possession couldn't be established. The case was dismissed on the absurd technicality that you can't be guilty of drug possession if the drugs were already in someone else's pants when you borrowed them. 10. A defense attorney successfully got a theft conviction overturned by arguing that his client couldn't have stolen the items because he was too stupid to understand that theft is illegal. The defendant had walked into a store, taken merchandise, and walked out without paying, claiming he thought you could just take things from stores. His lawyer argued that his client had an extremely low IQ, had never been properly educated about the law, and genuinely didn't understand that taking things without paying is theft. The prosecutor argued that everyone knows stealing is wrong regardless of intelligence, but the defense brought in IQ tests showing the defendant scored in the intellectually disabled range in psychological evaluations, suggesting he had the mental capacity of a young child. The lawyer successfully argued that his client lacked the mental capacity to form criminal intent because he literally didn't understand the concept of theft. The appeals court overturned the conviction, ruling that the defendant couldn't be held criminally liable for actions he didn't have the mental capacity to understand were wrong. The too dumb to know better defense worked because the lawyer convinced the court his client was intellectually incapable of understanding basic laws. 11. A lawyer defending a man charged with fraud successfully argued that lying to people to take their money isn't fraud if the victims were stupid enough to believe the lies. The defendant had run a scam convincing people that he could double their money through a secret investment strategy. He took hundreds of thousands of dollars from investors and spent it on himself. The prosecutor charged him with fraud, but the defense attorney argued that his client never actually promised guaranteed returns. He'd said it was an investment opportunity and investments carry risk. The lawyer essentially argued that the victims were fools for believing obvious lies and that being gullible isn't a crime, but taking advantage of gullible people also isn't a crime. The judge asked if deliberately deceiving people for profit wasn't textbook fraud. The lawyer argued his client had expressed opinions about potential returns, and opinions aren't facts that can be fraudulent. The case was complex, but the defense successfully created enough doubt about whether the defendant had made provably false statements versus optimistic predictions that the jury acquitted. The absurd argument that fraud victims deserve it for being stupid enough to fall for the scam actually worked. 12. A defense lawyer got his client acquitted of vandalism by arguing that spray painting graffiti on public property is constitutionally protected free speech. The defendant had spray painted political messages on government buildings. The prosecutor charged him with vandalism and property damage. The lawyer argued that political expression is protected by the First Amendment and that public property is exactly where political speech should be displayed. The prosecutor argued that free speech doesn't include the right to deface property, but the defense presented evidence that graffiti has been recognized as legitimate art and political expression. The lawyer argued that the government can't punish people for the content of their political messages regardless of the medium. The jury acquitted, apparently convinced that spray painting on government buildings is protected political speech. The judge was reportedly frustrated that this precedent would make it difficult to prosecute future graffiti artists who claimed political motivation. 13. A lawyer defending a woman charged with assault successfully argued that she couldn't be guilty because she'd been experiencing PMS at the time, which diminished her capacity for rational decision-making. The defendant had violently attacked her coworker during an argument. The defense brought in medical experts who testified about premenstrual syndrome causing mood swings, irritability, and reduced impulse control. The lawyer argued that his client's hormonal state at the time essentially made her not fully responsible for her actions. The prosecutor argued that PMS affects millions of women who don't commit assault. But the defense successfully convinced the jury that his client's PMS was so severe that she'd experienced a temporary hormone-induced mental incapacity. The jury found her not guilty by reason of temporary insanity caused by PMS. The verdict was controversial. Women's groups argued it reinforced stereotypes about women being controlled by hormones, while the defense celebrated successfully using a medical condition to explain criminal behavior. The PMS defense worked despite its absurd implication that menstrual cycles can excuse violence. 14. A defense attorney got a murder charge reduced by arguing that his client had been suffering from intermittent explosive disorder, essentially claiming his client couldn't help having violent outbursts. The defendant had killed someone in a rage during an argument. The lawyer brought in psychiatrists who testified about intermittent explosive disorder, a condition where people experience sudden episodes of aggressive behavior disproportionate to the situation. The prosecutor argued that having anger problems doesn't excuse murder, but the defense successfully framed it as a mental illness that impaired the defendant's ability to control his actions. The lawyer argued that his client's explosive rage was a medical condition, not a choice. The jury accepted this and convicted of manslaughter instead of murder, resulting in a much lighter sentence. The defendant got a reduced sentence because his lawyer successfully argued that having a bad temper is a mental illness that diminishes criminal responsibility. 15. A lawyer defending a man accused of tax evasion successfully argued that his client hadn't evaded taxes. He just didn't agree with the tax system and chose not to participate. The defendant hadn't filed tax returns for a decade and owed hundreds of thousands in back taxes. The prosecutor charged him with tax evasion. The lawyer argued that his client had philosophical objections to taxation and that forcing someone to pay taxes they morally oppose violates their constitutional rights. The prosecutor pointed out that everyone has to pay taxes regardless of personal opinions. But the defense claimed his client wasn't evading taxes. He was engaging in civil disobedience. The lawyer found obscure precedents about conscientious objection and argued that his client's refusal to pay taxes was protected protest. The jury surprisingly bought this argument and acquitted on the criminal charges, though the defendant still owed the money in civil court. The absurd "I don't believe in taxes, therefore I don't have to pay them" defense worked for the criminal case. 16. A defense lawyer got a drug-dealing conviction overturned by arguing that his client was simply a very generous person who gave drugs to friends for free, not a dealer who sold them. The defendant had been caught distributing large quantities of drugs to multiple people. The prosecutor charged him with drug trafficking. The lawyer argued that trafficking requires financial transactions, and his client never accepted money for drugs. He just shared them with friends out of generosity. The prosecutor argued that distributing drugs is illegal regardless of payment. But the defense found a technicality in how the distribution statute was worded that seemed to require proof of financial exchange for the enhanced trafficking charge. The appeals court ruled that without evidence of sales, the trafficking charge couldn't stand. The defendant was convicted of possession, but the serious distribution charges were dropped. The lawyer successfully argued that giving away drugs isn't dealing drugs, it's just being friendly. 17. A lawyer defending a stalker successfully argued that his client's obsessive behavior toward a woman wasn't stalking, it was unrequited love, and you can't criminalize love. The defendant had followed a woman for months, shown up at her workplace and home repeatedly, and sent hundreds of unwanted messages. The victim was terrified. The prosecutor charged him with stalking, but the defense attorney painted his client as a hopeless romantic who didn't understand that his affection wasn't welcome. The lawyer argued that his client had no criminal intent. He was simply trying to court the woman and didn't realize his behavior was frightening her. The prosecutor argued that stalking laws exist precisely because this behavior is harmful, regardless of intent. But the defense successfully created doubt about whether the defendant understood his behavior was unwelcome. The jury convicted on lesser harassment charges rather than stalking. The lawyer's absurd argument that obsessive stalking is really just aggressive courtship somehow reduced the charges. 18. A defense lawyer got an arson charge dismissed by arguing that his client set the fire as a religious ritual, not criminal arson. The defendant had set fire to an abandoned building as part of what he claimed was a spiritual cleansing ceremony. The lawyer argued that forcing his client to suppress religious practices violated his First Amendment rights. The prosecutor argued that religious freedom doesn't include the right to commit arson, but the defense presented expert testimony about various religious traditions involving fire rituals. The lawyer successfully argued that his client's intent was religious, not destructive, and that the fire was contained to an abandoned property, harming no one. The judge dismissed the charges, ruling that the fire was protected religious expression. The absurd precedent that you can commit arson if you call it a religious ceremony caused prosecutors significant frustration. 19. A lawyer defending a shoplifter successfully argued that his client couldn't be convicted because the store's prices were so high that taking items without paying was justified as necessity. The defendant had stolen food from an upscale grocery store. The lawyer argued that his client was poor and hungry, and that the store's prices were so inflated that paying would have been impossible. He essentially argued that stealing from stores with high prices is justified as a form of wealth redistribution. The prosecutor argued that theft is theft regardless of prices or economic status, but the defense framed it as a necessity defense. His client needed food to survive and couldn't afford the store's luxury prices. The jury acquitted, apparently accepting the argument that stealing from expensive stores isn't really a crime if you're poor. The verdict set a concerning precedent that theft can be justified based on the victim's pricing strategy. 20. A defense attorney got a reckless driving conviction overturned by arguing that his client drives recklessly all the time, so this particular incident wasn't unusual behavior, and therefore not reckless. The defendant had been caught driving at excessive speeds, weaving through traffic, and running red lights. The lawyer argued that reckless implies unusual or out-of-character behavior, but his client always drives this way. He brought in witnesses who testified that the defendant consistently drives dangerously. The lawyer argued that what's normal for his client can't be considered reckless, even if it would be reckless for other people. The prosecutor was baffled by this circular logic. The defense was literally arguing that being habitually dangerous means you're never reckless. But the appeals court found the original jury instructions about reckless behavior were ambiguous enough that the conviction was overturned. The absurd argument that you can't be guilty of reckless driving if you always drive recklessly actually worked on a technicality. 21. A lawyer defending a man accused of assault successfully argued that his client didn't assault the victim. He was defending himself from the victim's negative energy. The defendant had punched someone during an argument. The lawyer claimed his client practiced energy healing and could sense the victim's threatening aura. He brought in witnesses from the alternative medicine community who testified about sensing hostile energy. The lawyer argued this was a form of self-defense. His client was protecting himself from a spiritual attack. The prosecutor argued that punching someone because you don't like their energy isn't self-defense, but the defense successfully framed it as a sincere belief system that his client was defending against perceived threat. The jury acquitted, apparently accepting that sensing bad vibes justifies physical violence if you really believe in energy healing. The verdict was absurd, but the lawyer successfully convinced the jury that metaphysical threats warrant physical response. 22. A defense lawyer got a DUI charge dismissed by arguing that the breathalyzer was unreliable because his client had acid reflux, which causes stomach alcohol to rise into the mouth and create false high readings. The defendant had blown significantly over the legal limit, but the lawyer brought in medical experts who testified about gastroesophageal reflux disease causing mouth alcohol that breathalyzers detect but doesn't indicate impairment. The prosecutor argued that the defendant showed obvious signs of intoxication beyond the breath test, but the defense successfully created doubt about the accuracy of breathalyzer evidence in people with acid reflux. The judge suppressed the breath test results, and without that evidence, the prosecutor couldn't prove the case. The DUI was dismissed. The defendant walked free because his lawyer successfully argued that acid reflux can make sober people seem drunk to breathalyzers. 23. A lawyer defending a woman charged with check fraud successfully argued that his client didn't commit fraud. She just had bad handwriting and accidentally wrote the wrong amounts on checks. The defendant had written several checks to herself from her employer's account for amounts much larger than authorized. The prosecutor charged her with embezzlement. The lawyer argued that the amounts were mistakes. His client meant to write smaller numbers, but her handwriting was unclear even to herself. He brought in handwriting analysis showing the defendant's numbers were ambiguous. The prosecutor argued that the defendant had cashed the checks, knowing they were for wrong amounts. But the defense claimed his client hadn't noticed the errors until it was too late. The jury apparently believed that someone could accidentally write the wrong check amounts multiple times and not notice until they'd spent the money. The fraud charges were dropped in favor of minor bookkeeping violations. The absurd, "my handwriting is so bad I defrauded myself" defense worked. 24. A defense attorney got a trespassing charge dismissed by arguing that his client hadn't trespassed on private property. He'd simply refused to acknowledge that private property exists. The defendant had repeatedly entered a property after being told not to. The lawyer argued that his client follows a political philosophy rejecting private property ownership. He claimed that forcing someone to respect property rights they don't believe in violates their freedom of conscience. The prosecutor argued that philosophical disagreement with property law doesn't make trespassing legal, but the defense successfully framed it as civil disobedience and protected political expression. The judge dismissed the charges, ruling that the defendant's political beliefs, while incorrect about the law, showed lack of criminal intent. The absurd argument that not believing in private property means you can't trespass actually worked. 25. A lawyer defending a man accused of public intoxication successfully argued that his client wasn't intoxicated in public, he was intoxicated in his car, which is private property. The defendant had been found passed out drunk in his car parked on a public street. The lawyer argued that the interior of a vehicle is private space, not public, and that his client was exercising his right to be intoxicated on his own property. The prosecutor argued that a car parked on a public street isn't public. But the defense cited cases about vehicles being private spaces for Fourth Amendment purposes. The lawyer argued that if cars are private for search and seizure purposes, they must be private for public intoxication purposes too. The judge dismissed the charge, ruling that the defendant was technically in private space, even though his private space was located in public. The absurd legal gymnastics that a car is simultaneously in public but also private worked on a technicality. 26. A defense lawyer got a burglary conviction overturned by arguing that his client hadn't broken into the house. The door was unlocked, so he'd just entered without permission, which isn't burglary. The defendant had entered someone's home and stolen valuables. The prosecutor charged burglary, which requires breaking and entering. The lawyer argued that breaking requires forced entry, and since the door was unlocked, there was no breaking. He claimed his client had simply walked through an unlocked door, which isn't the same as breaking in. The prosecutor argued that breaking and entering includes unauthorized entry regardless of whether doors are locked. But the defense found old case law suggesting breaking requires physical force against a barrier. The appeals court overturned the burglary conviction, ruling that entering through an unlocked door doesn't meet the breaking element. The defendant was convicted of theft and trespassing instead. The lawyer successfully argued that if people don't lock their doors, entering their homes without permission isn't technically burglary. 27. A lawyer defending a child molester successfully argued that his client couldn't be guilty because he'd been viewing so much child pornography that he'd become desensitized and didn't realize what he was doing was wrong. The defendant had committed horrible crimes against children. The defense brought in psychologists who testified about pornography addiction and desensitization. The lawyer argued that his client's judgment had been so warped by pornography consumption that he'd lost the ability to understand his actions were harmful. The prosecutor was outraged, arguing that pornography addiction doesn't excuse child abuse. But the defense successfully argued for reduced charges based on diminished capacity from pornography-induced mental impairment. The judge accepted this argument for sentencing purposes. The defendant received a lighter sentence because his lawyer argued that watching too much illegal material made him unable to understand that committing the acts depicted was wrong. The argument was morally repulsive but legally effective. 28. A defense attorney got an assault charge dismissed by arguing that his client's violent behavior was caused by a Twinkie-induced sugar rush that diminished his capacity for self-control. The defendant had committed assault, and the lawyer argued that his client had consumed excessive sugar before the incident, causing a metabolic reaction that impaired judgment. He brought in nutritionists who testified about sugar affecting behavior. The prosecutor argued that eating junk food doesn't excuse assault, but the defense successfully convinced the jury that his client's sugar consumption had created a temporary mental impairment. The jury convicted of a lesser charge. The Twinkie defense became infamous as an example of absurd arguments that somehow work. The lawyer successfully reduced charges by blaming candy for violent behavior. 29. A lawyer defending a woman charged with poisoning her husband successfully argued that she hadn't intended to kill him. She'd only intended to make him sick so she could nurse him back to health and improve their marriage. The defendant had put poison in her husband's food. He survived and she was charged with attempted murder. The lawyer argued that his client loved her husband and only wanted him to need her care. He claimed she'd carefully calibrated the dose to sicken but not kill. The prosecutor argued that poisoning someone is attempted murder regardless of stated intent. But the defense successfully created doubt about whether the defendant truly intended to kill or just make him sick. The jury convicted of assault instead of attempted murder. The absurd argument that poisoning your spouse is really just aggressive relationship therapy somehow resulted in reduced charges. 30. A defense lawyer got a fraud conviction overturned by arguing that his client's lies were so outrageous that no reasonable person would have believed them. Therefore, the victims weren't actually defrauded. The defendant had convinced people to invest in a time machine he claimed to be building. He took hundreds of thousands of dollars. The lawyer argued that the claims were so obviously false that the victims should have known it was fake. He claimed that reasonable people don't believe in time machines, so anyone who invested deserved to lose their money for being irrational. The prosecutor argued that fraud is fraud regardless of how ridiculous the lie. But the defense successfully argued that the victim's own credulity broke the chain of causation. The appeals court overturned the conviction, ruling that lies so unbelievable they shouldn't fool anyone can't be fraudulent. The absurd argument that fraud victims who believe obvious lies weren't really defrauded somehow worked. 31. A lawyer defending a man accused of vandalism successfully argued that his client was actually improving the property, not damaging it, because art is subjective. The defendant had spray-painted elaborate designs on buildings without permission. The lawyer argued that his client was a street artist and the paintings were improvements that increased property value. He brought in art appraisers who testified that street art by recognized artists increases value. The prosecutor argued that unauthorized painting is vandalism regardless of artistic merit. But the defense successfully convinced the jury that determining whether something is damage or improvement requires subjective aesthetic judgment. Without proof the painting's decreased value, vandalism couldn't be proven. The defendant was acquitted. The absurd argument that you can't commit vandalism if you're creating art somehow worked. 32. A defense attorney got drug trafficking charges dismissed by arguing that the large quantity of drugs his client possessed were for personal use because his client had a really big drug habit. The defendant had pounds of cocaine when arrested. The prosecutor charged him with trafficking based on the quantity. The lawyer argued that his client was a severe addict who consumed drugs in quantities that would be trafficking amounts for most people. He brought in addiction specialists who testified about tolerance levels in severe addicts. The lawyer successfully argued that what's a trafficking quantity for normal people is personal use for hardcore addicts. The judge ruled that possession amount alone doesn't prove trafficking intent without additional evidence of distribution. The charges were reduced to possession. The defendant avoided serious trafficking charges because his lawyer successfully argued his drug problem was so severe that pounds of cocaine were just for his own use. 33. A lawyer defending a stalker successfully argued that his client couldn't be convicted because all the stalking occurred online, and actions in cyberspace aren't real enough to be criminal. The defendant had sent thousands of threatening messages, created fake profiles to harass the victim, and engaged in coordinated online harassment. The prosecutor charged him with cyberstalking, but the defense argued that online actions don't constitute real stalking because they occur in a virtual space. The lawyer claimed that unless the defendant had physically followed or approached the victim, it wasn't stalking. The prosecutor argued that cyberstalking laws specifically criminalize online harassment, but the defense successfully created confusion about whether digital actions have the same legal weight as physical ones. The jury convicted on lesser charges. The absurd argument that stalking someone online isn't real. Stalking partially worked. 34. A defense lawyer got a theft conviction overturned by arguing that his client didn't steal the item, he just forgot to pay for it. And forgetting isn't a crime. The defendant had walked out of a store with expensive merchandise without paying. Security footage showed him concealing items and avoiding checkout. The lawyer argued that his client fully intended to pay but genuinely forgot in a moment of absent-mindedness. He brought in witnesses who testified about the defendant's forgetfulness. The prosecutor argued that the defendant's deliberate concealment showed intent, but the defense successfully argued that forgetting to pay, however unlikely given the circumstances, creates reasonable doubt about criminal intent. The appeals court overturned the conviction because the jury hadn't been properly instructed about the role of intent. The absurd "I forgot to pay" defense worked on a technicality, even though evidence suggested deliberate theft. 35. A lawyer defending a man accused of insider trading successfully argued that his client hadn't engaged in illegal insider trading. He'd just made really good guesses about stock movements that happened to be correct. The defendant had made a series of stock trades immediately before major corporate announcements that perfectly predicted the news. The prosecutor charged him with insider trading. The lawyer argued that his client was a skilled investor with good intuition. He claimed the timing was coincidental, and that correctly predicting market movements isn't proof of insider information. The prosecutor presented evidence of connections between the defendant and company insiders, but the defense successfully created doubt about whether information had actually been shared. The jury acquitted, apparently accepting that someone could consistently predict unpredictable corporate announcements through lucky guessing. The absurd argument that perfect market timing was just lucky guessing worked. 36. A defense attorney got a DUI conviction overturned by arguing that his client wasn't drunk from alcohol. He was drunk from auto-brewery syndrome, a condition where the body produces alcohol internally. The defendant had blown above the legal limit but claimed he hadn't consumed any alcohol. The lawyer brought in medical experts who testified about rare cases where gut bacteria ferment carbohydrates into alcohol. The prosecutor argued that the condition is extremely rare, and the defendant had alcohol bottles in his car. But the defense successfully created doubt about the source of the alcohol in his system. The appeals court ordered a new trial with more evidence about the medical condition. The case was eventually dismissed when prosecutors couldn't definitively prove the alcohol came from drinking versus internal production. The absurd "my body makes its own alcohol" defense worked enough to overturn the conviction. 37. A lawyer defending a woman charged with fraud successfully argued that her fake psychic business wasn't fraud because her clients received exactly what they paid for: her opinions about their futures. The defendant had taken thousands from people claiming she could predict their futures and remove curses. The prosecutor charged her with fraud. The lawyer argued that psychic readings are entertainment services and opinions, not factual promises. He claimed that everyone knows psychics aren't really predicting the future and clients pay for the experience. The prosecutor argued that the defendant had made specific false claims about removing curses for money, but the defense successfully framed it as protected religious practice and opinion that can't be fraudulent. The charges were dismissed. The absurd argument that fraud isn't fraud if everyone should know it's fake somehow worked. 38. A defense lawyer got a murder charge reduced by arguing that his client was so angry when he killed the victim that he couldn't have premeditated the murder. The defendant had driven to the victim's house, brought a weapon, broke in, and killed him. The prosecutor argued this showed premeditation, proving first-degree murder. The lawyer argued that his client was in such an emotional rage that he couldn't have formed the rational thought necessary for premeditation. He brought in psychologists who testified about rage interfering with rational thinking. The prosecutor argued that the defendant clearly planned the attack, but the defense successfully convinced the jury that anger can be so intense that planned actions aren't really premeditated in the legal sense. The jury convicted of second-degree murder instead of first-degree. The absurd argument that being really mad means you can't plan ahead somehow reduced the murder charge. 39. A lawyer defending a man accused of rape successfully argued that his client couldn't be guilty because he was too unattractive to have committed the crime. The defendant had been accused by a victim who described her attacker. The lawyer argued that his client was so physically unappealing that the victim wouldn't have been his target. He essentially argued that attractive victims wouldn't be raped by unattractive rapists because it didn't make sense. The prosecutor was outraged by this argument, pointing out that rape is about power, not attractiveness. But the defense created doubt about identification by emphasizing physical mismatches between victim and defendant. The jury acquitted, apparently finding the argument about relative attractiveness convincing despite its absurd and offensive logic. The too ugly to rape defense worked in a case that showed how prejudice and absurd reasoning can overcome evidence. 40. A defense attorney got charges dismissed by arguing that his client couldn't be prosecuted because the law criminalizing his behavior was written in language his client didn't understand. The defendant had violated a complex financial regulation. The lawyer argued that the statute was written in technical legal language that a layperson couldn't comprehend. He claimed that laws written in incomprehensible language can't be fairly enforced because citizens can't know they're breaking rules they can't understand. The prosecutor argued that ignorance of the law isn't a defense, but the defense successfully argued that the regulation was so complex and poorly written that expecting compliance was unreasonable. The judge dismissed charges, ruling that the regulatory language was unconstitutionally vague. The absurd argument that you can't be prosecuted for breaking laws written in language too complicated to understand actually worked. 41. A lawyer defending a woman charged with embezzlement successfully argued that she hadn't stolen from her employer. She'd given herself an unauthorized raise, which isn't theft. The defendant had transferred her employer's money into her own account repeatedly. The prosecutor charged her with embezzlement. The lawyer argued that his client believed she was underpaid and had adjusted her compensation to fair market value. He claimed that employees who believe they deserve higher pay aren't stealing when they take what they think they've earned. The prosecutor argued that taking money without authorization is textbook embezzlement. But the defense successfully created confusion about whether unauthorized self-payment constitutes theft if the employee believes they deserve it. The jury convicted on lesser charges. The absurd argument that you can give yourself a raise by stealing company money partially worked. 42. A defense lawyer got an assault charge dismissed by arguing that his client's violent behavior was caused by consuming too much caffeine, which created a temporary psychosis. The defendant had attacked someone during a road rage incident. The lawyer brought in medical experts who testified about rare cases of caffeine-induced psychosis. He argued that his client had consumed multiple energy drinks before the assault, creating a toxic level of caffeine that impaired his judgment and self-control. The prosecutor argued that caffeine consumption doesn't excuse violence. But the defense successfully argued that his client had experienced an adverse drug reaction that temporarily eliminated his capacity for rational decision-making. The judge accepted this argument for a reduced charge. The "too much caffeine made me crazy" defense worked to reduce assault charges because the lawyer convinced the court that energy drinks can create temporary insanity. 43. A lawyer defending a burglar successfully argued that his client hadn't committed burglary because he didn't intend to steal anything when he broke in. He broke in to take a nap. The defendant had been caught inside someone's home and claimed he was just tired and the house looked comfortable. The prosecutor charged him with burglary. The lawyer argued that burglary requires intent to commit a crime inside, and napping isn't a crime. He claimed his client had only intended to rest, not steal, so it wasn't burglary. The prosecutor argued this was absurd and pointed to stolen items in the defendant's possession. But those items were charged separately as theft. The defense successfully argued that the burglary charge specifically required proof of intent to commit a crime upon entry, and the prosecutor couldn't prove what the defendant intended when he first entered. The burglary charge was dropped on the absurd technicality that breaking into someone's house to nap isn't burglary if you decide to steal things afterward. 44. A defense attorney got a perjury charge dismissed by arguing that when his client lied under oath, he didn't know he was lying because he has such poor memory that he genuinely believed his false statements were true. The defendant had given testimony contradicted by evidence. The prosecutor charged him with perjury. The lawyer argued that perjury requires knowingly making false statements, and his client's testimony was based on faulty memory, not deliberate lies. He brought in memory experts who testified about how unreliable human memory is. The lawyer successfully argued that his client believed his own false testimony, so he hadn't committed perjury. The judge dismissed charges, ruling that without proof the defendant knew his statements were false, perjury couldn't be proven. The absurd argument that you can't commit perjury if your memory is so bad, you believe your own lies actually worked. 45. And finally, a lawyer defending a man accused of murder successfully argued that his client couldn't be convicted of murder because, while he did kill the victim was such a terrible person that killing him wasn't really murder, it was community service. The defendant had killed a man who was a known criminal, abuser, and general menace to society. The defense attorney brought witness after witness, testifying about the victim's horrible behavior and the fear he'd spread through the community. The lawyer essentially argued jury nullification. Yes, his client killed someone, but the victim was so awful that the killing improved society. He argued that the law should recognize degrees of wrongfulness in victims. The prosecutor argued that murder is murder regardless of the victim's character. But the defense painted such a picture of the victim as irredeemably evil that the jury acquitted, apparently agreeing that some killings aren't really murder if the victim deserved it. The absurd argument that murder isn't murder, if the victim was a bad person, actually convinced a jury to acquit, despite the defendant admitting to the killing. The case became controversial as an example of jury nullification, and demonstrated that the right argument to the right jury can overcome even clear evidence of guilt. The brutal truth about ridiculous legal arguments is that they work more often than they should because the legal system is built on technicalities, jury psychology, and the requirement to prove things beyond reasonable doubt. These lawyers didn't win because their arguments made logical sense. They won because they found loopholes, exploited technicalities, played to jury biases, or created just enough confusion that reasonable doubt crept in. These cases prove that in law the truth isn't always as important as what you can convince people to believe. A skilled lawyer can take an absurd premise and dress it up in legal language, expert testimony, and emotional appeal until it sounds almost reasonable to a jury that doesn't understand the law as well as the lawyer does. The real absurdity isn't the arguments themselves. It's that the legal system allows them to work. Every one of these cases represents someone avoiding consequences for their actions because their lawyer successfully confused, manipulated, or outmaneuvered the system with arguments that ranged from questionable to completely insane. Subscribe if you want to remember that justice isn't always about truth or facts, that clever lawyers can twist logic until up is down and wrong is right, and that sometimes the most effective legal strategy isn't to prove your client is innocent, but to argue something so absurd that the jury can't figure out how to respond.